I called because I've been a helmet choice activist in South Nevada, and I live now in Utah, which has no helmet choice. So I can ride my motorcycle with or without a helmet. So I've been a helmet choice activist for about two and a half years or so. And I've gotten a total of 9 tickets, and I've got 3 of them are outstanding. And I've been kind of hitting my head against the wall, and really I haven't tried to get tickets. What I do, because Nevada, but similar to Arizona, is an open carry state. So when I wear my controversial headgear, I always take a gun with me, like an open, like a big old .45. So that has minimized the number of times that I get pulled over in Las Vegas. But nonetheless, I have still gotten pulled over 3 times. And the one time was that I'm dealing with right now that I want to talk to you about is in the city of North Las Vegas. They have a court of non-record there. And I figured, it would just be dismissed or whatever, because we've had other helmet citations there. And there was actually a judge there who said in his courthouse, he said, the law does not matter in my courtroom. And,
whoa. So the law does not matter. Wow.
I swear to God, Mark. And not only that, but there is you're not allowed to bring any kind of electronic equipment into that courthouse by judicial order by their judges there. And that means no cell phone, no nothing, unless you're an attorney or unless you're one of the statist drones that works for them. You are not allowed to bring in anything. So everything that they do is 100% top secret. So the amount of misconduct that I have seen, the brutality, the sadistic behavior by these marshals against some of the people that are there. You pick a number and you have to wait up to 3 hours to be seen by a window lady. And there was this old man who stood up, and the marshal by the last name of Gomez said, "You need to sit down." And he said, "But I've been sitting for a long time and I got a bad back." He goes, "Well, then step outside." And he goes, "Yeah, but my number's coming up and I've been here for a long time." And he goes, "Well, then I suggest you sit down." And I'm thinking, this could not happen if we had recorders or if somebody was there and they were held accountable, but they are doing a bunch of things.
It's called, Barrycam. Barrycam.com. We can get cameras in there, but you are it is civil disobedience and has a risk of going to jail and, of course, losing the camera. Well, let me ask you, we got time. Where in Utah are you?
I call it Polygamyville, Utah, but it's called Central Utah, and it's north of St. George. It's not really in the center of Utah. It's about 120 miles from Las Vegas. Oh,
okay. And did this judge, and he said the law has no place in my courtroom, is that what he said?
He said that to my colleague when I was I wasn't really an activist so much. I was just reporting for a motorcycle magazine, and I went there as a reporter. And, of course, I wasn't allowed to bring my video camera or any kind of recording device or a cell phone or anything. So I had to rely on my notes, and there were other people there as well. And we all heard the judge say, the law does not matter in my court.
Oh, does not matter. The law does not.
Yeah,
wow.
And he said it to him in the context of this guy who wanted to bring in case law, Hannigan versus Easy Riders or something out of California, where it went up to the Ninth Circuit Court of Appeals that it was ruled that helmets cannot be used as probable cause to give a citation. The question of whether or not the person is wearing a legal helmet can be used as reasonable suspicion to pull over and to inspect, but it cannot be used as the reason to give a citation. So that was what he wanted to introduce, and the judge says, "Hey, you know what? No, I'm not even going to look at that. The law does not matter in my court." So,
you say, well, can you tell the cops that because they seem to think it does, or else why are they charging me? I mean, seriously, what an incredibly stupid, short-sighted comment to make. The law does not matter in my court. Then why am I here? Why are the cops filing complaints with you? Don't take it up with me. My gosh.
Well, and not only that, the judge was not even a lawyer. He's an elected judge, or was an elected judge. He just retired last year in June. but he was elected, and he's a retired cop for that jurisdiction, for that area. And he was a detective for a while. So, of course, he's there, they've got such an incestual, obvious, transparent relationship, the judge and the prosecutors and the cops. And when you go and you defend yourself, because when you go into the courthouse, probably any courthouse in the country these days, you're not allowed to take your weapon, but the cops are allowed to take their weapons. So when you're facing your accuser, he's got a gun and you don't. So is there not a balance of power issue there?
Well, yeah, I questioned him just the other day. I said, why? Because you have to have a metal detector that when you go to the court, and I said, why?
Right.
Why can employees walk around it? I mean, haven't you ever heard, of, the post office, where it's usually employees that are flipping out and shooting up the place? Yeah, he did not see he just looked back and he says, I don't think we have to worry about these ladies. I said, I'm glad you're so concerned. I said,
right.
Yeah, no,
right.
There is an absolute double standard. It's like when you go to Superior Court in Phoenix, the employees and the prosecutors walk around. Who knows what are in their briefcases? So this guy was trying, because I brought that up, and the guy says to me, he says, the judges, they don't even come through there. If the judge wanted to shoot the place up, he goes through the back door anyway. He could bring in whatever he wants. Yep. I said, I'm really glad to hear that security is really, you're that concerned, because it's usually someone who works at the place who gets fired and comes back and shoots the whole damn place up. But they're not concerned about that. But, I don't want to sound like I'm harping on this. Which court did this happen where the judge said the law does not matter in my court?
The city of North Las Vegas. It happened in North Las Vegas. Yes.
Oh.
And I actually took a video recorder, and I did something very stealth, that could have gotten me in jail. But I took an audio recorder because I had been arrested for videotaping a cop. I was 30 feet away, but it was my son who called me, and I didn't want my son to get Rodney King, because he's an open carrier too, and he's 30 years old. So I showed up with my video camera, and the cop told me to go away, and I wouldn't. So I got arrested, and I got an obstruction charge, which I was found guilty in their top secret court and non-record, but for $12 I appealed and was found not guilty in district court. So the point being that these guys have a history of just the misconduct with these courts and the cops is just something that is like, people don't believe it unless you actually. So anyways, when I appealed, because the judge forced me to have to pay my money before I could even appeal. So I paid like $500, and then I appealed. And then when I went to go get my money back, I showed up back to that courthouse that doesn't allow the stuff, the electronic equipment, and I went in there like flaming, and the marshal says, "Did you leave your cell phone?" And I said, "Yes, I did." And then she goes, "Well, what's that in your hand?" I said, "It's an audio recorder." And she goes, "Oh, well, you can't. What's that for?" So anyway, she didn't want me to go in there, and I said, "Well." Yeah, so I said it's just an audio recorder.
TigerLily, just a second. We're on. I know you can't hear. We're going to be going to a break here. Welcome. We'll be back here on the No Say Project in just a moment. Don't go away. So obviously, a recording device is for recording.
Right. It was an audio recorder. So she says, "Oh, are you recording me right now?" I says, "Yes, I am." And she says, "Well, you can't. This is a two consent party state, blah, 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 blah," which was, she was lying in the sense that I did have the authority, the right to record her, because there was no expectation of privacy for her or anything. But they tried to bully you and everything. But what she didn't realize is I had my daughter-in-law behind me. She was wearing my spyware glasses. So when I left, so we captured the whole thing, all her lies and everything, and I turned off the recorder and everything. So it just goes to show that Oh, and then we went to the city council to try to tell them, look, while my daughter-in-law was here for my son because he was arrested because he was open carrying, she was unable to get a phone call that her daughter needed her in school, and that's because we're stripped of our phones, we're stripped of all contact with our family, we're stripped, and it's just appalling what goes on. So, anyways, sorry, I got off a little bit off track, but I wanted to talk to you about my brief because I was found guilty, no surprise, for the helmet violation, which I just rolled over, and basically I knew they were going to find me guilty, and I figured I'd go to a real court of record. So what I did on my appeal is that I asked the judge if he would let me do a briefing schedule. So he said yes, I guess he has to because he's on record now, right? So that's what I've been working on, and it's due on Monday. So I'm talking about last minute stuff. I know, but I've been working my butt off. But the thing is, I'm doing it traditionally, whereas with you, you've got this whole out of the box philosophy on how to approach things. So I'm going to do kind of a little collage of each, or kind of merge them because I don't have time to really to study you as well as I wanted to, and kind of ram home some of the issues of the fact that I was wrongfully given a helmet ticket, and as evidenced by the fact that I have the whole transcript. The guy didn't realize I was recording him, videotaping him. He thought I was just audio recording him, but I got a whole HD video on him. I was detained for over 30 minutes. After 5 minutes, after the first minute that I was detained, he says he asked me questions about my gun. So was it really about a helmet ticket, or was it to search me for my gun? And then they put me in this I call it the pre-rape position, where they made me hold on to the bumper, for a whole 30 minutes, and so that they can ask me questions about my gun and try to search me, and I'm trying to say no, I don't consent, and all of this kind of stuff. So, anyways, you have to go back to your show.
Well, we record the off-air stuff for the podcast,
okay.
So I will be coming back in a moment. I don't like to interrupt the flow of the conversation, even though I write down, I would write down what we were talking about. But the brief is, what happened at the trial? I mean, that's really, it's going to help.
At the trial, the first thing I asked at the arraignment, I asked the judge. It was a female judge. I asked, could I record my trial? And she said, this is a court of non-record. And I says, I understand that, but it's on, you have the authority. She goes, you're going to have to ask a lawyer. That's what she said. And so I have a lawyer friend, and he says, yeah, record. So then I went back, and then when at the actual hearing, the trial, it was a different judge, and I said, well, your colleague told me that for me to ask a lawyer, and I did ask a lawyer, and he said yes. So since I had talked to a lawyer, and he said yes, will you give me permission to record this trial? And he said no. And I said, well, would you be so kind as to at least make a record of that in the notes? So he did. He did live up to that. So it's on the record that he denied me my request to.
Well, hold on. Here, welcome back to the No State Project. We're here live, LRN.FM, and also carried by TruthFrequencyRadio.com. My website, of course, is MarcStevens.net. We're talking with TigerLily from Vegas. Well, actually, Utah, and you're relating to us what happened on a previous charge for no helmet, and you found guilty, and that you have a brief due. Get this, everybody, it's due Monday. So at least it's not a trial on Monday. That's evil. So walking me through basically what happened at the trial that you would be bringing up as a point of error in the brief.
Well, I don't know that I can even bring up as a point of error in the brief because since the City of North Las Vegas Courthouse is a court of non-record, I get a trial de novo, so nothing is supposed to matter. You know what I mean?
Well, wait. All right. Yeah, I do know what you mean. So why would you have a brief due on Monday if it's a trial de novo?
I have a brief because I asked for a brief to address some of the constitutional issues surrounding the fact that I got this helmet ticket and the unconstitutionality of it. And I wanted to bring up, before I knew you, I was going to bring up the unconstitutionality of the fact that I was seized as a person. I was bullied into giving up my fifth, under coercion.
You have a fifth? Whoa. What, vodka or scotch? Or what are we talking about, fifth?
The Fifth Amendment, the Fifth Amendment to actually the Fourth, and also the Fifth too, but the Fourth Amendment right to be free from unreasonable searches.
Are you sure that that's a right that you have?
I know that we don't have any rights. Okay. I know it now.
Okay.
but the learning curve is like, what can I say? I got a thing on Monday, and I'm learning this just like 2 weeks ago. I discovered you, and I've been doing this for 2.5 years. Fighting the system with the system.
Oh,
so it's
sure.
like now you took me out of this whole box, and it's like, holy cow. So what I was going to do is argue the merits based on jurisdiction, like I've been trying to understand that you've got, and I've read half of your book already, and I also wanted to, since I'm still in the box, in the other box, 2.5 years of fighting with their own rules, I wanted to argue the constitutionality of the 5th, the 4th, even the 2nd and the 1st and the 14th and the speedy trial. I don't remember which amendment that is, because it takes a whole year to get justice, or the so-called justice.
Well, the speedy trial. Wait, the speedy trial part's not going to be from the federal Constitution, and that's going to be something that you can look in the Nevada Constitution if this is happening in Nevada. It may be considered a due process issue under the 14th, but specifically, you would look for in the state. Well, right. Jurisdiction can be raised at any time, even for the first time on appeal. Did the prosecutor and the cop present any evidence whatsoever to prove that the code was applicable?
No, not that the code was applicable. No, I didn't even know. I didn't know that myself. And like you said, especially in a court of non-record, they're just going to say, "Oh, that's a given."
Well, they may say that and say, "Oh, I understand." So it's not beyond a reasonable doubt. I got it. I understand. The thing that what I'm trying to get out of this, though, is to make some sense about the brief. Are you actually, because there's a difference between saying that the actions taken by the judge violated, or the prosecutor violated the Constitution, as opposed to where you're claiming that the statute you're accused of violating is unconstitutional.
I wanted to bring both of those up.
Okay, and I think that's probably why. I think it's the latter, that if you're saying that the statute is unconstitutional, that may be why a brief is due to bring that. But you should still be having a trial an actual new trial, like what Rich in Austin is going through, to have an actual retrial. For the issue, to have the witnesses come in and be prosecuted again, the way you normally would on a trial de novo. I'd have to look at the paperwork that they got you, and I have to check the rules to know if that's exactly what they're talking about. Because if that's the way it is, then saying that the judge violated due process is, and violated the Constitution that way is not going to be something they're probably going to consider.
Right.
So I don't know. You'd have to take a look at that. Because from what I've seen, if you screw it up that way, it gives them an excuse to not look at any of it. Well, you raised issues that were not about the constitutionality of the statute here, so we're not going to consider the brief. I don't know. I don't know if they would do that or not, because I tend to like with the motion. Yeah, you find out, because with the motion, because they play games where they don't want to tell you if it's civil or criminal. We just put both in there. To me, it's the easiest way to get around that crap. When they start playing that game with you. So find out. There's not much we can do. It's due Monday. It's due Monday. You don't have much time here.
Well, when I appealed my obstruction case, I also asked for a briefing schedule, and what I did was lay out some of the constitutional issues, the constitutionality of the fact that the judge had found me guilty because I disobeyed a law. But the premise I went through, the way I attacked it, was the law was not it was not a legal law. I mean, how is it lawful to say you can't record when you're at a safe distance and you're not interfering? And they're the ones that came to you. You're not the ones that you didn't interfere with them. They interfered themselves by coming to me. So the judge looked at it, and they had their turn to reply, and then I replied. And then when push came to shove, and it came the trial date, which my trial date is going to be on the 29th of January for this specific case, But for the other case, when I finally went to the trial, the judge basically said, "Screw you! You ain't a lawyer. You know, this is obviously not written the way that we're used to, or whatever." And he said, "We're going to have a trial." So I fully expect that we're going to have a trial. But the fact that I can just brief it kind of helps me kind of organize my thoughts. But I think better than that, I think my energy would be better used is if I went on ahead and used some of your templates and your questioning for in court and do my trial that way.
Yeah, I've worked with a number of people that, with that. In fact, if you see some of my videos, if you check out the videos, one of them, you'll see the document from one of the North Vegas prosecutions. Oh, yeah, I've heard they're bad. They're particularly bad out there.
Very bad.
They're bad all over. But to say something that the law does not matter in my court, that's one of the dumbest things I've heard come out of one of these psychopaths' mouths. That tops the list. Yep. I had North Vegas. Yeah, that's another stain on North Vegas. Like they needed more. Yeah. Wow. Well, the templates are good. You know, it raises all the issues of the jurisdiction. I would suggest getting on the phone with the prosecutor on Monday and asking him point blank, what facts do you rely on to prove that the Constitution and Code are applicable to me? And that the court has jurisdiction, and take it from there. I would put his statements into the motion to dismiss so that you can use it against him. Because this is something I spoke to. Get this, the guy's name, Richard Rocky. And he is a
R-O-C-K-Y?
No, it's with an H. There isn't. Okay. That's why I was. When I first called, I was a little up in the air about the name. Was it really Rocky? That's cool. So he called me back the other day, and we were asking, and I asked him, Rocky. Hey, yo, Rocky, what facts you rely on over here? So he tells me that now, when asking for the facts that the code is applicable, this is what he said to me. The fact I saw him violate the code. Right? Now, he didn't understand. I said, well, you do understand. That's circular. I mean, at best, it's putting the cart before the horse. I mean, how is seeing a violation evidence that the code applies in the first place? He said,
right.
So he said, I don't want to discuss it with you anymore, Mark. And your client can raise that argument in court. It's not really an argument, but okay. I don't think he's going to be any more willing to discuss it when it gets to court. But he is one of the witnesses. There hasn't been a prosecutor assigned to that one yet. But these are things that you can use against them. And
do you likewise have templates to how to deal with cops and how to ask them questions to kind of get them to get a little light bulb turned on? You have that as well?
Yes, I have a script for that.
Cool. Okay.
Well,
I'll find it.
It's you want to keep in mind you want to role play with people. Get on the forum and the No State Project chat, the Skype chat, and you want to spend some time role playing because you want to stick to just 2 or 3, maybe 4 issues, and that's really all you need to do. The big one is the applicability of the code, of course, and we're going to be going to a break. We'll be back with TigerLily in just a moment, so don't go away. The biggest thing is sticking on point to where you're asking for just the facts. And I know that Penny had this issue, but, and a lot of people have the issue. Well, how do I respond to X, Y, Z that they may say? Well, your only issue there is, well, is it responsive or is it not? Now, Richard Rocky said this to me, and others have said this too. He's not the only one. It's a very standard response, if they give you one at all, that, well, I saw you violate the code. That's not an answer. Yes, it's circular. Right. I get, it's circular. But it's not, more important, it's not an answer. So it's a matter of practicing and role-playing, and because you're getting into things that are, quite different than what you've done before. And sometimes you're going to say things that sound good. You could ask, well, factually, what is the Constitution? So that's the supreme law of the land.
Well, I've done kind of a little bit of Stefan Molyneux even before I knew him. A little bit of having them search in their hearts. Oh, you're gonna really? Are you really gonna give me a ticket because you don't like my helmet? Because you don't see that it says DOT on it? Because and so are you the same kind of person that would have put Rosa Parks in the back of the bus? And they're like, oh, well, I don't know what I would have done.
Have you experienced that with them though? I mean, have you gone through that conversation?
Yes, I have done that. I've gotten out of 2 tickets because of that. On one of them was not the Rosa Parks, but I said something like, well, you know what? It's a helmet today and it's an oven tomorrow. You're just following your orders, huh? That sort of thing. So I've brainstormed these kind of thoughts in my mind and what I could say to them, and I have had some good luck. I mean, in 2 instances, I got they just let me go without a warning, without anything. And in one other instance, the guy actually said, "Okay, what will help your cause better, to give you a ticket or to not give you a ticket?"
Wow.
Yeah, and you know what? I aired that on YouTube, and the guy is probably still he had to hire an attorney because they wanted to get rid of him.
Wow.
He says, I just had 18 months left to retire. You really messed me up, but it's like, I'm sorry, I really didn't mean to hurt him, but I was eager to show people that you can appeal to people's sense of morality to get them to think twice about what they're doing. Are you serious? You're going to make me pay $300 for a ticket for something that I didn't harm anybody, that only 1/3 of the states still have this archaic, ridiculous law on the books? You're going to make me go through all of that? You're going to make me have to choose between feeding my family and paying you guys for something that, please, are you serious?
Yep.
So that's kind of what I've been doing.
I generally, I've done that. And I generally get, I used to do that with the IRS because I'm on the phone with the IRS all the time. And the more I learned about psychopaths and antisocial behavior, the more I realized I shouldn't be doing that. Because I at least with the people that I deal with, it started to become apparent to me that it was actually driving them harder to know that they are causing physical pain. And we know from the Stanford prison experiment that within 6 days you could become sadistic and get a pleasure out of hurting other people. So I stopped doing that. But I guess in other situations, and you've got evidence of that. In other situations, it may be, you may have some success. I just won't do it anymore when I'm dealing with tax agents because I think that it's just not effective. It's not making them back off.
Right.
Not that way.
It makes them feel that much better to know that they're abusing you.
Yeah, so that's why you don't do that. But if you're in a situation where you believe that this person can be touched or you can connect to them on that level, then obviously you've had some success with that, and that's great.
Right. I also tried the same tactic with the prosecutor recently because my most recent helmet ticket was in Bunkerville, Nevada, which is right like 4 miles from the border, to Utah. And I was going to put a big old helmet because I didn't want a helmet ticket when I filled up for gas, but I got pulled over before that. And the cop says, well, anyway, that's another story. But the prosecutor, I went to the arraignment, and this was before knowing you. And I said, look, this is how it's going to be. If this is a court of non-record, if I get found guilty, I'm going to pay my $12 or whatever it costs to get to appeal it. So, and then he said, well, why don't you just wear a big helmet? And I said, well, why didn't Rosa Parks just go to the back of the bus? And he goes, I cannot believe you are comparing yourself to Rosa Parks. And I said, no, there's no comparison because what she did was civil disobedience. What I'm doing is following the letter of the law. And so he says, and then so since that didn't work, I tried to appeal to his sense of sensibility. And I said, well, do you really want to consume so much resources of taxpayer money to prosecute me? Why don't you just dismiss it? And then he says, well, it's obvious you're enjoying this. You're smiling. And I says, I guess I'm smiling because, number one, I'm nervous. And number two, if I do anything wrong, you have the power to get me arrested right here, right now, because I am on your turf. and so he was cordial. He gave me his card, the dummy. Gave me his card. I got his name. I got his email. I called him, and I've sent him a couple of emails. And to where I sent him a link to a trial my colleague who went to the only trial that I know of where he was found. It was a full-blown trial in a court of record in Las Vegas, and he was found not guilty because the prosecutor was unable to show the judge where the standards are because, Mark, those standards do not exist. It is a completely unenforceable law.
Okay. If you want to focus on that part.
So that trial that was put on YouTube, it's gotten close to 400,000 views already with thousands and thousands of comments because people are like, wow, and it's absolutely true. The prosecutor tried to find the standards, even the judge. You can see him scrolling through. He's got the benefit of all of these resources. He was unable to find the standard, and he really, really, really wanted to crucify my colleague because his helmet was the size of a 4-inch disc. A little CD on top of his head. And he says, you could tell that the judge was pissed off because how dare he mock his he takes it as a personal affront to his court. But he had no choice but to find him not guilty because the standards is actually federal standards which apply to manufacturers, not to end users. It's like saying, okay, people cannot make clothes for babies that are not flame retardant. If you make them that are not flame retardant, then you're violating this federal statute. But you can't apply that to the parents that are putting clothes on the babies.
Right. Yeah.
And that's the same thing with the helmet law. It's the exact same thing.
And so that on that video gets thrown out. The ticket, the complaint
he gets found not guilty. Not only does he get found not guilty in that verdict, the judge, the defendant said, "Well, Your Honor,
hold on. Welcome back to the No State Project. Believe it or not, we are in the third hour of Anarchy Radio here on LRN.FM, and that's the way it works out. We're going to do our best to get everybody. We're still on with TigerLily, and she's just we're talking about what happened. And there's a video that she has. It's gotten over 400,000 hits, and this is where a colleague of yours was found not guilty of a helmet violation. It's
youtube.com/guerrilla lawfare. And just like it's spelled properly, guerrilla lawfare with no spaces or anything. And there's over 400,000, I believe. He's toppled 400,000 views on this video, which it's 3 parts, and it's a total of maybe 30 minutes. And the verdict was that he was found not guilty of not wearing a DOT-approved helmet. Because there is no standard, no standard that applies to end users. It's a complete myth. And when people, what he managed to do was expose this myth. So then at the very end, when the judge, he's a real a-hole. He was yelling and he was just, spitting, bullets through his eyeballs and everything. And so the defendant said, well, Your Honor, how do we tell, the cops keep telling us, tell it to the judge, and yet they're still pulling us over. And he says, well, the only reason I found you not guilty is because the prosecutor was unable to find those standards. But he claimed to be assured that the standards do exist. He would not admit that they didn't exist. And he says, well, then the defendant wasn't letting them go. He's like a pit bull. And he says, well, what do I do? And so the judge says, well, get yourself another helmet ticket, and this time it's not going to be dismissed, or we will prosecute it. It will get prosecuted appropriately. Well, he got himself another ticket and got it in that judge's court, and the judge called in sick. He did not show up. So it was dismissed.
Oh. You see, he was required to recuse himself to begin with, but he calls in sick.
Yeah.
Yeah.
So it was a rent-a judge that day. So yeah, if that's a really lovely case. And and thank you so much for talking to me. I'm going to finish up these brief. I'm so sick of it, and I'm going to focus more on how I'm going to defend myself when it comes time to my trial is set for the 29th of January, and I'll keep you posted.
29th of January. We'll definitely stay in touch and get on the. I can put you in the No State Project chat, and you get with we can help role play and get you prepared for that. And let me know let me know if you need any help with the brief.
Oh, great. Thank you so much and your work is heroic.
Oh, I appreciate. I don't know about that, but I do appreciate I appreciate it. Thank you.
As always, I want to remind everybody that I ride to be free, not to be safe. So, repeal it or feel it, bitches.